Well, if they put it into the joint account, knowing in their head, okay, here's the money and here's how we got to divide it up, but now they're going through a divorce, do you really think that that spouse isn't going to try to get that half of that account? Hi, Jeff Marsacci, the Plain English Attorney, and welcome to the video. Today we're talking about the sole beneficiary disaster and how this ends up being a huge problem with a lot of people when they're putting together an estate plan and they've got the wrong mindset, the wrong mentality about it. Or, let's face it, they just don't want to make a decision. They don't even want to think about it. And so they end up passing the buck, usually to the oldest child. So let's talk about exactly what we mean by the sole beneficiary disaster. I hear this not frequently, but every now and then. And for whatever reason, it seems like they're having a lot of difficulty really kind of nailing down what the problem is. Oh, I'll just leave everything to the oldest child and they'll take care of it. Whoa, huge problems with that. First of all, some of this stems from a misconception that the oldest child is taking care of it. Now, we have four big questions, just going to go over it very quickly. The first one is, who do you trust to handle financial things for you if you become incapacitated or you pass on? We look for one person, then a backup, then a third. This ends up being the list of the executor of the will or the pour-over will, the trustee, the power of attorney for finances. That's the list of who is in charge if you can't handle it yourself. Second question we ask is, who do you trust to handle healthcare decisions? So separate types of decisions, but again, one person, a second person, then a backup. The third question is, after you die, who gets what, when do they get it, and how do they get it? And this is the estate piece with, okay, if it goes to these equally to my 3 kids, and if one of them passes on, here's where it goes. And so it's encompassing all that. And the fourth question is usually about guardianship. They're conflating the first and the third question. Oh, well, obviously I want my oldest kid to be in charge of making it happen. But then they're saying, no, they get everything, as if they were the only beneficiary. So what's the problem with that? If you just leave it to them and let them handle it. Well, what you're really doing is you are passing the buck and not making a decision on who the actual beneficiaries are going to be. You're just saying, oh, they'll be fair with it. Well, okay, here's the first of the disasters. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. One, they have absolutely no obligation to share that with anyone. And it does come with other problems right along with it. So the first thing, if they're not obligated to do it, but, oh, I know they will do it. I've got 4 kids, the oldest, there's no problem. They'll just divide it up. But for whatever reason, the clients or the prospective clients aren't willing to say, yes, I want my estate divided equally. Oh, no, they'll take care of it. Well, no. You can have that oldest child in charge, but you have to list, here's how I want it to go. If they receive everything and then they talk with an attorney and then they have a change of mind, it's like, well, okay, I have $2 million. I can keep $2 million. Or I can divide it up so I only get $500,000 and I have to give the $500,000 to these other siblings of mine, some of which seem to be pretty arrogant, or they upset me. There was something that ticked me off at mom or dad's funeral. I don't want to give it to them. An attorney told me I don't have to. I'm going to keep it. Look, families fight. It's very emotional when somebody passes on, and it's entirely possible that that one beneficiary is just going to say, I'm going to keep it. And they're not going to get called out on it. Well, they'll get called out on it by the kids, but the court's not going to call them out on it because you wrote out in your plan, here, I want this oldest child to get everything. Okay, that's it. End of story. They are the beneficiaries. All right, what if they aren't going to do that? No, I 1,000% trust they're not going to do it, and maybe they don't. Well, this also now comes with some other issues. What if they receive the money and then they pass on? Do you expect their widow or widower to just say, well, wait a minute, all that money is now coming to me. Should I have to distribute it to these, my deceased husband or deceased wife's siblings? That looks pretty good to me. Look, they passed on. It was younger than we thought. We've got kids that need to go through college. I'm not going to do that. I'm going to keep the money. They can. And again, they go to an attorney, and because it stated, okay, it went to their spouse, there was no obligation in the documents that said you have to split it up. It's theirs. What if it isn't the spouse, it actually ends up going down to their kids before they get a chance to split it among the siblings? So in other words, that oldest child ended up dying. All right, now the grandkids, maybe they don't like their cousins or their aunts or uncles. They were mean to them at the funeral. There's absolutely no obligation to get it to these other, quote, beneficiaries, because they weren't beneficiaries because you didn't list them out. All right, what if, even if they do all of that and they divide it properly and they say, yes, I'm going to give it to them, there are actually tax issues that go along with this now. If there are any inheritance taxes for that particular state, and there are a few states that have them, North Carolina isn't one of them where I'm licensed, but okay, there's an inheritance tax. 100% of that tax gets placed on that oldest child, and now they have the obligation to pay all those taxes. If they take the taxes out and then divide it, now suddenly all the kids are like, well, wait a minute, why did you, it was this much money and blah, blah, blah. Well, it was taxes. Oh, well, I talked with my attorney or I talked with my accountant and those taxes are your problem. Okay, again, becoming more of an issue. What if there's the gift tax issue? Some states actually do have an actual, honest to goodness gift tax where if you give money away, there's a cap on it, and if you exceed the cap, you actually pay a tax. Now, at the federal level, right now, currently, it's $17,000, so anything above that, you don't necessarily have to pay a tax, but you have to file a gift tax return, and if it exceeds your lifetime exemptions for estate taxes, then you do have to come out of pocket. So you're potentially also giving your kid, that one oldest child, a gift tax problem. Why? Again, all of this gets avoided if you just lay out who the beneficiaries are. And on top of that, they have a fiduciary obligation in order to execute the plan properly. So there isn't this gift tax problem. What if they say, oh, well, okay, I talked with my accountant and we don't want to fill out gift tax forms or whatever, so I'm going to give it out in $17,000 increments each year until it's all gone to the beneficiaries. But again, they could pass on and there's no obligation for their survivors to take over and fulfill that obligation. So that's just on the tax end. All right. What if that particular child ends up in some kind of legal crisis? And there are a few big ones that we try to guard against. What if they're in the middle of a divorce and they just happen to receive all that money and go, oh, well, I'm just going to put it into this joint account? Well, if they put it into the joint account, knowing in their head, okay, here's the money and here's how we got to divide it up, but now they're going through a divorce, do you really think that that spouse isn't going to try to get that half of that account? They probably are. And now suddenly, even though it was an inheritance, it's thrown into risk. What if the oldest child, at the time they start receiving this inheritance, they're actually having some creditor or bankruptcy issues? Now suddenly that money may be on the table for any of those creditor issues. Now, I can probably hear some of the attorneys or other professionals out there say, well, it's an inheritance. You don't lose it in a divorce. If you kept it separate, if you put it into the joint account, yeah, it's a problem. But even if you put it into a separate account, That's not going to insulate you saying, oh, creditors, I spent all of this money and I owe you money, but this was an inheritance that I received. You can't have that. Oh, yeah, they can go after that. Inheritances aren't protected outside some kind of trust setup with just putting it into a bank account saying, well, it was an inheritance. It doesn't work. Now, there's also issues. What if it's to the point where there's some kind of disability or Medicaid is needed and you've got, quote, too much assets because you received this inheritance? It has to get spent down. And you can't gift it away under Medicaid's rules within 5 years. So now you really are stuck. You're not going to be able to get the care that you need because you received all of this money outright in your name, and you can't do what mom or dad said they wanted you to do, which was spread it out among your other 3 siblings, and there you go. You can't do it without Medicaid coming down on you. Now, all of these cases, all of them, just to recap, if you actually answered that third question, who gets what, when do they get it, and you didn't just pass the buck and say, hey, I'm going to leave everything to the oldest kid and let them take care of it so that I don't have to make that decision. No. Now suddenly, if it's in ideally a revocable living trust, that it's divided 4 ways. You can still have your oldest child as the trustee. If they're having any of those issues that we just spoke about, creditors, bankruptcy, divorcing spouse, disability, Medicaid, it's not their money that's going to the other 3 kids. It's not. And if they do have some kind of disability or there's creditors and lawsuits, they can resign and let the next person take over, and the good revocable living trust will have creditor protection against divorce, bankruptcy, and all those other things written into the document, and the other trustee can protect them. So ideally, you shouldn't ever just be saying, oh, I'll leave it to the oldest kid and let them divide it up, unless what you actually want is that oldest kid to receive everything and you're cutting out the other kids. It's worth taking the time. For a lot of my clients, it's less than 15 minutes in this process of running through. Here's where you want it to go. You want it, oh, you've got 4 kids, you want it equally to those 4 kids. You say, yes, it gets divided 4 ways. You don't say, nope, give it to the oldest and let them handle it. It's 4 ways. If a child passes on, where do you want it to go? Do you want it to go to their children and descendants, or do you want it to go to the other 3 kids? And usually it's the grandkids, the descendants. And, well, if they pass on too, very uncomfortable. Okay, then it goes to the other 3. Taking that time, like I said, less than 15 minutes just to run through, here's exactly what I want to have happen, and a couple of layers of contingencies. You are taking all of those burdens off of one beneficiary saying, here you go, you divide it up however you want, and now you have a solid plan. So please, if you're ever doing your own estate planning and you're starting to think about how do I want things divided up, don't just pass the buck and say, give it to the oldest kid and let them handle it. No. Take the time and the responsibility to go through, here are the different contingencies and here's how I want it divided. I'm not passing the buck. So I hope you found that information useful. As I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.